thank you very much for coming. The purpose of today really is to talk about how SMEs deal with large corporates. And it's not, I'm trying not to be too technical and legal, if I'm perfectly honest about this today. It's more, how on earth do you position yourself and what sort of support can a law firm like ourselves give you in dealing with what can sometimes feel like an absolute nightmare in terms of very large companies who are very uninterested in doing anything other than dealing in their own set way. And you, as a small or medium enterprise, feel a little bit almost scared potentially or unknowing as to what to do. And more importantly, you're really worried about losing that contract. So someone's come to see you, that it's your big customer, you've been trying to get this person hooked up for ages, and then they've hit you with the contract, and now it's the detail. You want to deliver it, and you quite simply might actually just be going to sign it whether you like it or not. And so I think when you do that, a lot of people come to their lawyer and say, "Oh, I'm really sorry," or they ask for they almost expect you in a teacher-like relationship to tell you off for signing up to these extraordinary terms. And that's not how a helpful way of working, actually. What you need is someone who's on your side, who understands what you're going through, and maybe be able to help you unpick some of those problems that dealing with a large corporate involve, and possibly give you some guidance to maybe get yourself in a slightly better position than just rolling over and saying yes to everything. And I think to do that, you need to really understand a bit about them that you may seem all obvious, but is often not always a given. And then really understand about you. And it's amazing how many small and medium enterprises take what they do for granted. So this talk is really about understanding them and understanding you and how you fit together. So the first thing is understanding them. Who are you actually dealing with? What sort of company is it? Is it a large multinational of which it's a subsidiary in the UK or somewhere else? And actually, the main decision making is made elsewhere in the world or at a different office. Are you a national company of which you're dealing with a satellite? How are they set up? What are their red lines? What do they want from you? When do they want it delivered? And we'll look a little bit about all of that, because understanding that allows you to meet their requirements in a way that suits you a little bit better. So it's really useful to listen actively to who you're dealing with, how they're approaching you, and understand what they're really after and what you are value adding to them. And with that, you then need to understand yourself. What are you giving them? What are your risks in delivering to them, to their requirements? You've asked them what they want and when they want it. How are you going to deliver that? What are you supplying and how are you going to do it? Who is your risk to supplying? And what could possibly go wrong? Really understand that. And sometimes people don't like to think about all those bad things. But if you have a clear idea of what you know and what your problems are, and we'll look at these in a little bit later, you can then deal with your customer in the most efficient way. And actually, once you understand a bit about them, once you understand exactly how you're going to do things, you can come together and have your next conversation under the contract. So, bit about understanding them. Who are you dealing with? Contracts with large corporates don't just drop out of the sky very often. More often than not, you'll have been talking to someone in one of their teams somewhere, and your team is probably small, agile, lots of people do lots of different things. In large corporates, that's not the case. You quite often will be dealing with one person, but they may hand your contract over to a procurement team. The legal team will want to put something in. The compliance team might want to get involved. The HR function might be involved. The finance team will almost definitely be involved. There will probably be group teams in large multinationals for this, that, and the other. All of these are feeding in to who you're talking to, and who you're talking to might not actually be the most important person in the conversation. And it's really useful, without obviously putting that person off, to understand how they sit, who you're dealing with, and where various decisions are coming from. Because in a large corporate, there is who's got the budget is a very big question. It is not a small organization where all decisions come to one person. Budgets will have been set and you will be working within some function's budget. What do they want to achieve? And what are they trying to do that you allow them to do that they can't do? Because they wouldn't be coming to you unless you had something special. And typically that's not their normal core business. Otherwise they'd be doing it themselves. So you are an important part of taking whatever function it is you're dealing with to where they need to be for the greater good of that business. And you need to remember that you are giving them something special, but you need to also understand what are your risks in that delivery and how are you going to do that? When you're talking to whoever it is at the large corporate, you may find that they are in the R&D team, the research and development team, or they're and they're going to hand you over to the procurement team, which might be based in another part of the world. They may actually not be internally aligned, and that's not an unusual situation, which means you're dealing with, in one sense, with one person who is completely keen to buy your product, and then they hand you over to somebody who really doesn't care less because you're a small part of a much bigger problem they've got, and it doesn't, and actually this contract isn't as important to them as another one they're working on. So you need to understand that and actually take heart from the fact that just because they are slow, they are a little less agile than you, it doesn't mean they're not interested. But it is important to keep aware of who you're dealing with and how, and make sure your contact is absolutely in the right place and you're pushing in the right buttons. But find out who owns this project, find out who owns the budget and try and get to them, because it's them who will help you get to the best position in the end of the day. So then you need to understand a little about yourself, and hopefully you do know what your risks are in supplying the customer. But it's amazing how many people don't really understand the risks of providing their product to any end customer, let alone a large corporate with very, very restrictive terms and conditions. What are the integration risks with that customer? Whether that's just picking up a phone number and have you got the right people and contact numbers right the way through to IT, integration of systems and various other things, depending on your supply. What are the critical, are you part of a wider supply that they have entered into? So if you're in construction, they've got a multi-100 million pound project and you're a small part of that. If you're in IT, are you a small functionality within a much wider offer to a large government organization or something like that? It is really important to understand how you interface with the wider offer and understand that you know what you're going to give and what you need back from them before you can give it, because dependencies are big issues down the line when things start to unravel if delivery becomes a problem. So understand you really well, because, and also once you know what you need and what you need to get to deliver, you'll be able to, in a much better position to have clear and focused conversations with your corporate contact and make sure that the big points are dealt with with focus, rather than worrying about what will be in a typical markup, lots and lots of red pen. I'm a great believer that you want to get your key points out there early, not huge numbers, hopefully, and be really clear that those are what you need to have from them in order that you can deliver for the best for them. It also means commercially you gain alignment, but know where your risks are, because if you don't, you may have to accept some risk. And if you don't know the extent of those risks, you don't know what you're accepting down the line. And that's, again, something that you can be helped with proactive and pragmatic legal support. Understanding them, back to them. When you deal with a large corporate, it can feel like a bit of a maze. You can be, one day, they want everything done immediately, and then suddenly there's silence. That's nothing probably to do with you. It's more likely to be their own internal processes, and they're all working very hard. But typically, a large corporate will come and see you. They'll say, we want this, we want to pay that much, and we'll place a purchase order. This is great news. But typically, they put all project risk on you. They say they're non-negotiable. But actually, you typically will find your service isn't typical to their standard terms and conditions. And actually, their terms don't work very well, or they're not quite relevant, or you need some help from them, or they have to input with you in order for you to do what they to get. Sorry, you require input from them in order that you can deliver to them. And without that input, you're unable to deliver. And most terms and conditions do not have this multifaceted toing and froing to protect you. It only protects them. And if they keep changing their minds or don't respond, you can get delivery failure, and it can be your liability and not covered. Really important to have these conversations up front. Typically, the first contract that gets sent to you is you're told it's non-negotiable. But actually, very rarely is a contract completely non-negotiable. It does happen, but it's rare. And the question is, how far can you push your concerns and get yourself into the best position without losing the contract? And that is always a difficult balance to weigh up. I often hear customers and clients, they're talking to that about these big contracts. They go, I don't want to annoy them. I don't want to lose the deal. Does it matter? Oh, these terms and conditions, nothing ever goes wrong. We don't need to worry about it. And quite often, small, medium enterprises will have a sales team who have absolutely no interest in the terms and conditions and the worries of delivery, because they're only interested in the next sale. They want to get the sale, they want to move on. And this is a big one. So it's a very difficult balance as an SME to weigh up, what are you willing to lose the contract for, and what are you not? And the simple answer to that might be you're not willing to lose the contract and you're going to sign it anyway. But you don't need to say that straight away. But if that is the case, you don't need to say sorry. It's your business. It's your choice, and it's you who needs to make those decisions. It's not your lawyer. We're there to support you in whatever decision you make. Understand that you're making those decisions with your eyes open and get you in the best place to make sure that the worst never happens. And I think when you look at a contract in those terms, it is very different from looking at a contract in a, oh, I'm sorry, my lawyer, I've done this, haven't I done badly? No, you've done what you needed to do for your business. Get the support that you get and how you mitigate and reduce the risks of failure are also ways that your lawyer should be able to help you. So, why are these terms and conditions so terrible? So often I hear clients will say to me, well, it's just the terms and conditions, they're fine. But quite often the terms and conditions are the best possible position they could ever achieve. That is generally how a set of terms and conditions is set up. Even in SMEs, you will have the same position. You'll have sales terms and purchase terms that are the best that you can have, and they suit you and they take all risk away. And a large corporate is no different. They're more used to getting their own way because they're a large corporate and they've got lots of money that small and medium enterprises want to get. So they've got big contracts to offer and therefore big bargaining power. However, they do have significant risks in almost every clause of one of those terms and conditions. I'm going to highlight some just now, but these are just a few of them, and different businesses have different risks. And so different businesses need to look at it. It comes back to the know your key risks and understand what your offer is so that we can then work to get those risks reduced through the contracting process. Typically, terms and conditions will have fixed pricing, absolutely no right to change anything, which may be fine, but it may be completely inappropriate for your style of service. You may have a discovery phase in supply, or you may have a design phase, which is going to throw out a lot of differences. And the original purchase order value is simply not going to be the right number by the end. That can be a big risk if you enter into a contract that doesn't allow you to change the prices. Further, they almost always contain benchmarking clauses. So if you've agreed a long-term supply, they then have a right later on to come in and try and get your price reduced, which, bearing in mind you've agreed a long-term supply, may be a problem down the line, because you may have had to sink some costs across the term of the contract into your supply, because there were upfront costs that you weren't able to put in during the initial phases of the project. Rights to terminate if they can find it cheaper. These are all problems that if you have a long-term contract, you need to have addressed so that the cash ultimately coming into you isn't a problem for your supply and your business. Contracts typically have rights to delay or cancel or terminate for convenience whenever they want, however they want it. Again, your 3-year term may not be a 3-year term. And if you've committed to suppliers and sunk costs and they terminate 6 months down the line or a year, you may find yourself exposed. So you need to understand that, and you need to be absolutely clear. Is your contract for as long as you think it is? And is the pricing right? And can you back up that pricing? Most purchase terms do not contain a liability cap, which means you have exposure of unlimited levels for any breach that you cause, which, linked to what are likely to be very heavy warranties, makes the liability and the cap on your liability a potentially business critical risk. Now, you may be willing to take that risk, and you will need to talk about that and what you do about that if you are entering into uncapped liability contracts. But my strong advice is, and most business and practice is, that most of my experience is that uncapped liability is not a reasonable position for a purchaser to take, and almost all procurement people that I have ever come across will accept some form of cap on liability. And that is a really important thing to know. It is normal for people to cap their liability. Procurement professionals and procurement teams will tell you otherwise, but it is absolutely normal. Quite a lot of agreements in terms and conditions don't even contain an obligation to purchase. So you've got to be really clear. Are they actually going to do what they say they're going to do? Design and responsibility is often placed all onto the supplier. So if you are a small cog in a much wider project, it is very difficult for you to actually give the sort of warranties that they're expecting. Is your product fit for purpose, or are you supplying to a specification? In most cases, people are supplying to a specification, and yet the contracts say that you'll meet a particular purpose. And these are very difficult things to meet and often unknown. Very important to make sure your intellectual property is protected. Your business is special. They've come to you because you've got something that they don't have. It's great. Keep it, because you need to be able to use it for your other customers, your other clients. And if you don't, or if you inadvertently give it away or give rights to your customers to use it in a way that's not helpful or doesn't protect its confidentiality, you may have lost your business. So intellectual property is absolutely vital. Most terms and conditions of a purchaser will take IP and transfer it to the buyer. That might be fine, but it might not. Unreasonable rights to terminate on the slightest delay. It is very common to see time of the essence, which is a clause that lawyers love to get excited about. But the reality is, it means if you're even the slightest bit delayed, they can terminate the entire contract very easily. And delays happen. It's also completely unreasonable to expect a 1 or 2 minute delay to enable a termination. And probably not what they'll ever do. But if down the line they're looking for ways to get out of a contract, or if down the line that things have happened that they're not quite happy about, it just more rights to allow them to actually not live up to their contractual obligations. Liquidated damages, again, risk that just need to be considered, and you just need to, but normally you can discuss and reduce their scope. The other thing to watch out for is expensive additional requirements, compliance, audit, spares. Do you have to keep spares? How long for? How much do you have to keep backups, document retention, corporate social responsibility obligations, which as a small and medium business, you simply can't comply because they have the most extraordinary number of functions piling out wonderful, responsible processes that you can't comply with. Are you signing up to doing an awful lot of things that you simply haven't thought of or haven't included in the prices? These are all things that you need to work on and just have available to you. So we come back to understanding you again. How do we deal with that maze? Once you know your key issues, do you have any red lines? Is there anything that's going to make you walk away from this contract? 9 times out of 10, the answer is no. I get that. So our problem then is, how do we deal with that? You know what they want, and how do you therefore make it as safe as possible for that delivery? There are lots of different ways to deal with this, and sometimes it's as much as asking. It's the relationship you have with the person you're dealing with. They will sometimes tell you, you need to do this, or we'll never exclude that, or we'll never accept any changes. They might accept certain changes in certain areas. So you may find that they don't want to deal with their legal team. That is very common with large corporates. And therefore, how do you get through their maze, helping them not go to their legal team? So what are the ways that they have found around that? And that is a big surprise often to small and medium enterprises, that large corporates are not all aligned with themselves. I mentioned it at the beginning, but how do they like to deal with their legal team? How does their legal team typically deal? And it's those conversations, listening to who you're dealing with and understanding the needs, that allow you to try different routes to dealing with some of those problems I mentioned earlier. That might be in a schedule of amends. It might be in a set of special conditions. It might be on a full markup in highlight of the document. But there's no right or wrong. But if you can get some idea and some feels from it, it allows you to address the issues. Be inventive. They will want this contract. You both want this contract and you both want it signed quickly. Most companies are reasonable. They sometimes will accept markups. They sometimes won't. Sometimes they will accept schedules of amends. Sometimes they will require them in special conditions that are elsewhere in the document. So all of those things your lawyer can help you with and take you through the journey. Join the calls sometime so that you can explain why these are big issues. And then understand that they've seen that hundreds of times before, because their terms and conditions are always considered unreasonable by everyone. So give them a chance to tell you how you might best deal with it, and then focus your comments and your concerns around what your key risks for delivery are. Most contracts are price, product, and payment. What's the price? What is the product and how is it delivered? And when are you going to get paid? If you really focus in and understand that, you won't go a million miles wrong. So then, back to you. Understand navigating the maze. Understand what happens if you can't change. What are you going to do? If they can terminate it for convenience, how are you going to deal with it with your suppliers? How are you going to make sure you are not left high and dry by their slowness or their changes of corporate direction or this, that, and the other? So what is the important factors that really are really important for you to deliver to them? And if you talk to your counterpart about that, generally they understand that, because and they will then work with you to get to the end. So don't panic, understand them, but don't be afraid to stand up to them as well, because they are used to it. They've done it a lot. That's a bit of a whistle-stop tour. I know it's only half an hour and we've got 4 minutes left. If there are any questions that anyone would like to talk or would like to just contact me afterwards, do please feel free.